On the record in the matter or matters of the state of Michigan versus Michelle Craig, 25-00275, 25-01217.
This one's Alyssa's fault from a few days ago. We're circling back because there was nothing in court today.
25-01226.
Yeah, I apologize. Ms. Craig just took over the tape.
I'm sorry?
I apologize, Your Honor. She hadn't approached her yet. I didn't know if she was going somewhere.
Haley Fortuna on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Craig for the file ending in, I apologize. On the file 25-01217 only, I believe Mr. Kareem Johnson represents her on the remaining two files.
Good morning, Mayor. Please the court, Kareem Johnson on behalf of Ms. Craig. Your Honor, that is correct.
Okay, today was the date scheduled for pre-trials on this matter. Looks like we have a file with dog stray, another file that's dog at large, vicious dog, and then allowing DWLS. How we proceed on this?
Your Honor, the people would move to dismiss the DWLS. That's 25-01217 against Ms. Craig. We did receive documentation from defense counsel this morning, and it's our understanding that Ms. Craig does now have a valid license and the people would move to dismiss.
No objection.
What are we doing with the dog cases?
Your Honor, the number that I have for Ms. Craig was not valid. I need to verify that she has either got a license for the dog or no longer in possession of the dog. I did speak with the prosecutor in this case Friday, and if we can establish that, I think they'd be willing to dismiss this case. I do not believe the dogs belong to her. They belong to her son or another family member, but the dogs were still residing at the house.
The number that you have is correct, ma'am.
She's indicating the number in our system is correct, which is 517-888-6555.
That's the number we have in our file. Is that the number that you have, Mr. Johnson?
Let me pull it up on the file, Your Honor. The number I have went straight to voicemail. I have 88865.
That's what we have. She said that's valid.
Okay.
Did you want us to put her in the meeting room so you can talk to her? Or I don't know what you...
Sorry about that. I obviously didn't want the phone number on there.
Yeah, that's fine with me, Your Honor, if we can address this today.
Okay. We'll put you in that. You have your phone with you? What do you mean? Excuse me? All right, do you understand what's going on today? Because I've noticed your behavior. You seem a little disoriented.
Your Honor, may we approach?
Of course, her attorney who's on this file can't approach.
Understood. I've been trying to get a hold of him, but I don't have his contact information. I have fortunately get all of it. I think
Okay. You probably want to go off or meet or discuss this with her other counsel. So
I think that went something like the cheese is off the cracker.
if we could log her in and then you'll talk to him and then she can speak.
I can do that, absolutely.
Is Mr. Raleigh back in here?
I think he's sitting just outside. Would you like me to join on mine or on the court tablet?
We can put her on the court because she needs to speak to him privately and then you
Understood.
will probably have other matters to address.
Very good, thank you. She gets the iPad. Has some just walk. He did, yes. He was the 8 a.m. this morning that you put a 48-hour hold on.
You have a file? Where's Miss Craig?
She set up the hall. She was just outside the door.
Miss Craig? Okay, back on the record in the matter of the state of Michigan versus Michelle Craig. And this is in file numbers ending in 275 and 226. Just met privately with Mr. Johnson. However, I have a concern that you're under the influence of something. You're under the influence of the Holy Spirit.
Ma'am,
So if I have you remanded and tested, it's going to be clean. Did you answer my question?
Ms. Craig, I advise you to remain silent at this point in time.
I'm going to have her taken into custody for.
You're under the you're under the influence of the Holy Spirit. So that means the drug test will come back negative, right? Right.
DBT.
Yes, Your Honor. Ms. Craig, do not make any statements to anybody.
You know that you're responsible for my ID. You have paperwork you had a year ago.
You're talking to him?
I'm talking to you.
You're not talking to me.
I am.
You know you're not. As you can be held in contempt, you keep talking to me.
It's gonna go downstairs.
Your Honor, on behalf of Ms. Craig, it is my intention to ask the court to adjourn this pretrial. I do have, after speaking with her and speaking with co-counsel, some serious questions about her competency, criminal responsibility, based on statements that she made to me.
I can understand that. The matter will be adjourned, and so is your intentions to submit paperwork for her to have a competency evaluation.
Yep, that seems about right.
Yes, Your Honor.
Okay. We can do June 30th. We'll reset it to June 30th. At what time? 10:30. 10:30. Does that work for you?
Yes, Your Honor. And can I check back in to get the results of this potential bond violation?
Yes.
Right. Thank
We'll be
you.
here. Thank you.
Yes, sir.
It's being broadcast or whatever you call it.
Okay.
All right, good afternoon. We will begin in case 25M001076. It's entitled The People of the City of Marshall versus Leonard Jr. Cusino. Is that your name, sir?
Kuzno.
Cusino.
Leonard Jr. Kuzno.
Yeah, I keep mispronouncing it. I apologize. I forgot that I needed to broadcast this on YouTube, but we had gone through what the citation alleges, which is an expired plate. And
Oh, I'm just getting railroaded here.
that we're going to be you're scheduled for a hearing today. When I asked whether you wish to admit or deny, you indicated you initially
All right. Thanks to Leonard's Unite. Zach over there sent this to me. He did a good version of it. It's made the rounds. Everyone's done it, but I haven't seen it. And all I know is that in a little twist, this guy attempts to railroad the court instead of the court railroading him.
wanted to deny responsibility because essentially you had a motion to dismiss. Is that correct?
Yes, I had no motion to dismiss.
And this motion was your first statement to the court was that you indicated the Michigan Motor Vehicle Code was not, at least this violation was not applicable to you because you weren't driving in a commercial sense. Is that
Thank you,
correct?
Biggin.
Yes, and I'd like to ask the officer if I was hauling anybody or unloading or loading anything in my car.
Well, I will ask
That would
the
say
officer,
I
were
was
there,
commercial.
Officer Dickinson, was there anyone else in the vehicle?
There was not.
Okay, and well, Mr. Cousineau.
Kuzno, you got
I
it.
will get it right one of these times, and I'll keep getting it wrong.
Yeah.
I mean no disrespect. Okay, so I think that the officer would grant that you were
Just go with Big Dummy. It's easier.
not driving for commercial profit in any way.
Yes.
At least that's my understanding. Is that correct, Officer Dickinson?
Affirm.
Okay. So go ahead with your motion, I suppose, sir.
I motion to have it dismissed.
Well, on the basis just that the Michigan
on
Motor
why?
Vehicle Code.
Okay,
Yeah.
yes, hold on. The enhancement caused by the commercial MVC covered by the traffic law enforcement education, yes or no? And then the Michigan Vehicle Code Act 300 of 1949, an act provides the registration, titling, sale, transfer, and regulations of certain vehicle operations upon the public highways of this state. So the Officers Act clearly states that only certain vehicles are liable to the Michigan Motor Vehicle Code. Do you know the vehicles are liable to be regulated? Answer yes or no.
All vehicles. Well, it seems like you're reading from a questionnaire and it's
I'm
a
reading
flowchart
from,
of some sort. So the idea is, here's what I can tell you. Here's what I can tell you about the law. Okay.
Yeah, it's about the law.
Michigan Compiled Law 257.255, which is part of Public Act, well, the Michigan Motor Vehicle Code, Michigan 1949 Public Act 300, applies to it applies to any motor vehicle being operated on a highway or other place open to the public, whether it's for commercial purposes, for entertainment, for to reach a destination, for any purpose. If it's a motor vehicle and it's operated on the highways, Michigan Compiled Law 257.255 does apply. And the Michigan law does require that all motor vehicles, no matter what their purpose is, well,
it doesn't. Michigan's compiled law, the Supreme Court ruled not against that.
What case was that, sir?
Hold on. Let me get it. Let me get it here. Okay, quoting from Grand Rapids, GH&M RY Company versus Stevens ETAL 219 Michigan 332 1922 at 337.
Okay, what does it say at 337 there? On page 3037, what does the Michigan Supreme Court say?
It says 337, a highway is a public way for the use of public and general passage and traffic without distinction. Star versus C&A Railroad Company, 4 ZAP 597. The restrictions upon the use of only such as are calculated to secure to the general public the latest practical benefit from the enjoyment of the easement. And the inconvenience must be submitted to when they are only such as an incident to a reasonable use under impartial regulations. When the highway is not restricted, it is dedication of some particular mode of use. If that is open to the situation methods and cannot be assumed that these will be the same from age to age, or that new means a making way useful must be executed merely because their introduction may trend to be inconvenience or even to injury of those who continue to use road after the same manner as formerly a highway established for the general benefit of
Oh, sweet Jesus! What?
of use, whether it's found that the general benefits requires them and the law should prelude the adoption of the use of the methods. It would defeat in greater or less degree the purpose for which highway are established.
Okay, I am looking at that case. The first thing I would let you know is Do you know what the Grand Rapids GH and MR company is?
Railroad.
Right, it's a railroad. So this is a case from 1922, 103 years ago-ish. And it's a case where the Michigan Supreme Court was essentially ruling about rules and regulations on a rail that's on like a streetcar, essentially,
Oh my God, this poor judge looked it up and read the damn case.
a rail that's over a highway in an easement. It has nothing to do with a person traveling in a sedan in 2025 on a public roadway. I understand your argument. Do you have any other kind of cases that you think actually apply to this situation?
Yes, here's another one. Each citizen has the absolute right to choose for himself mold and conveyance he desires, whether it be wagon or carriage.
I understand.
Horse,
So
motor.
I'm not trying to be rude. I might be succeeding. I'm trying to be more efficient. I think your argument is, please correct me if I'm wrong, that somehow the requirement that you have a registration plate on your vehicle is an impediment to the constitutional right to travel. Is that correct?
No,
Okay, what are you telling me then?
ordinary use on a public road. Nothing
What about
commercial.
I didn't say anything about commercial.
No,
I
was
said,
just
are
saying
you
nothing.
trying to tell me that the law that requires you to have a registration plate is illegal because there is a constitutional right to travel?
Yes. No.
What-
No.
right. Okay, what are you telling me then?
Ordinary use of the public road.
Right? What about ordinary use of the public road?
A fundamental right.
The right to travel. I'm familiar with the
Yeah.
argument. It's been made by others. You're not the first and probably not the last to make that argument. I have ruled before, and I would rule
Yeah.
again.
Yeah.
The idea behind the thought that it's unconstitutional to require somebody to have a license plate on their car or to have insurance or something like that is an unconstitutional violation of the right to travel is simply not true. The Michigan Court of Appeals has decided that, and frankly, that's a misapplication of the phrase right to travel because, of course, there's nothing that requires you to travel by personal motor vehicle and choose to do so voluntarily. And then if you do so, Michigan requires that you have insurance. It requires that you have a non-expired registration plate. You could still travel to Ohio or any place else you want. You could do it by foot. You could do it by train. You could do it by bus. You could ride in somebody else's car, right? But the idea is
not the right
there
to
is
travel,
no
then.
right. It's the requirement that you have a registration plate and that it be current does not run afoul of the U.S. Constitution's right to freely travel. Now, is there any other argument you want to make about your motion?
It's just the right to use the public highway, not to
We all have
travel,
the right
to
to use it
it.
and the right to the right of the government in Michigan to say you can use this public highway only if you have an operator's license, you have a valid registration plate, and you have a minimum amount of insurance does not run afoul of the Constitution.
Yeah, that's not what I see the law says. That's why.
I understand we may disagree, but frankly, the
Yeah.
court interprets the law, and that's why I'm here. So I'm going to deny your motion to dismiss. Do you still wish to have a hearing on the case, or are you willing to admit that, on that day you did not have you had an expired registration plate on the vehicle?
No, I guess I'll have to go to court.
Okay, well, here's how this works. It's an informal hearing. So what I'll do is I'll put both of you under oath. The plaintiff in the case, which is the city of Marshall, represented by Officer Dickinson, has the burden of proof. The burden of proof in a case like this is called by a preponderance of evidence. After I put you both under oath, Officer Dickinson, who has the burden of proof, will present her case first. There aren't any rules of evidence that we have to worry about. There is one rule about the presentation, and that is that the court can consider only evidence which is relevant. After Officer Dickinson presents her case, Mr. Cousineau You're going to
Yes, you got it.
present your case.
Perfect.
Finally,
Yeah.
you get to present your case. Again, you can produce anything into evidence that's relevant. And after both sides have
Okay.
presented their cases, I'll render a decision. Either side can appeal that decision within 7 days. Mr. Cousineau, if you were to appeal the decision, then you would have to put up the fines, costs, and fees as a bond pending appeal. Do you understand the process at this point?
Yes,
Okay. Can you both raise your right hands, please? Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Officer Dickinson
I do.
and Mr. Cousineau.
I do. I do.
Very good. Officer, if you would begin, please.
Around 7:57 a.m. on 4/25, I observed Mr. Cousineau traveling on West Michigan Avenue with a green expiration date of July 2024 on his license plate. When I stopped him, he explained that it was in storage and that he didn't have the current registration and that somehow it got missed because he was moving because Ford was buying his house down in Michigan Ave. I explained to him that I had Lean in my computer, which is a law enforcement information network, and it's connected to the Secretary of State and updated as current as their system is, and they confirmed that his registration was expired, so I wrote him a citation under the Michigan Motor Vehicle.
I mean, this is obvious, but he is an excellent judge. Very, very friendly and very knowledgeable and prepared for this completely stupid argument. He's seen it before, and instead of being rude, he thought, nope, I will explain it. I will actually explain it. To his credit.
Code 257.255 for expired registration.
All right. Anything further you want me to consider at this point, Officer Dickinson?
Look at you.
All right. Mr. Cousineau? Is there
I'd
anything?
like to know where I didn't have a green sticker, I don't think, on my car. It's a military plate.
Okay. Anything else you want to say?
That's all I have to say, really. Except
Okay.
that, you know,
Officer Dickinson, I guess I don't know what color the plate stickers were or anything else. Do you have a recollection about whether this was a military plate or not?
I'm looking at my body cam right now. He does have a Army plate, possibly.
Is it a state of
So it
Michigan
does
sort of
look a little-
commemorative plate that says that
Yes,
has the
with
like,
the
US
Army
symbol?
decal
Okay.
on the right-hand side. So you're right. He had no sticker that I'm seeing at all. So I must have got the July 2024 date from the computer where it says the date that it expired. I'm mistaken. I did not see a green sticker. I'm sorry.
Sorry, Mr. Cousineau, are you the registered owner of the vehicle?
yes,
Okay. And I take it your birthday is in July?
yeah.
Okay. And anything else you want me to consider, Mr. Cousineau?
Just consider that I had an appointment to get everything, and you know, I just got it out of storage. Isn't
Okay.
there a leeway in that?
No, but I will consider it. It doesn't change whether you're responsible for the civil infraction or not, but I understand why you want to say that, and I understand that predicament. Anything else, Officer Dickinson?
No.
All right. Well, I've listened very carefully to the testimony, and it's pretty much undisputed that the defendant was operating a motor vehicle on West Michigan Avenue back on April 25th of 2025. And from both parties, but the officer had testified that she noticed that plate had been expired. She checked the law enforcement information network. It indicated it was expired. And Mr. Cousineau has testified here today that it was a military plate. He had gotten it out of storage and he had an appointment in the future for the Secretary of State so he could make that plate be essentially not expired. Given those facts and those circumstances, I do find you responsible. It cost you $700 to get that?
Yeah, 700 and some dollars.
All right.
It was over
And you went-
700.
And you went and paid it?
Yes, yeah, I paid
Okay.
it when my appointment was up.
Well, in light of that, I do find you responsible, but instead of assessing $110, what I'll do is assess $90 because I think you got, I mean, the Secretary of State penalized you quite a bit financially.
Yes.
But I do obviously have to enforce the law as it's written. So what I'm going to do is indicate that I'm finding you responsible. You'll have to pay $90. Total fines, costs, and fees. Can you have that paid by July 15th, or do you need more time?
Yeah. I gotta get to Battle Creek. I moved now, so I'm
Well,
ways
you can,
away.
I believe they have a way you can pay it online now, or you can pay it in the mail.
Oh,
if you
I
use a
can do
credit card,
that, yeah.
yeah, if you use a credit card, they'll add a credit card fee. But do you want me to give you till the end of July? Will that help?
Yes. They send a check to him, a personal check, or no?
Yeah, you can. Basically, when you get a copy of the judgment, if you have any questions about how to pay it, you can call the district court clerk's office, which is the same number you
Okay.
called originally to say you wanted an informal hearing. Does that make sense?
Okay. Yes. Do you have my right address now?
Well, I don't know. That's what, that's the next thing I was going to ask.
It's
The notice that we sent.
9009 McCain Road.
I don't think I have that. So hold on before we let you go here. All right. What's 9?
49269.
4926. I'm going to say it one more time out loud. All right. Basically, what's going to happen is I'll draw up a judgment. It'll go out in the mail tomorrow. It'll take a few days to get to you. Just make sure you have it paid off by July 31st. Okay.
Okay. Thank you.
You're all set for today, sir. Have a good day.
You too.
Good morning, ma'am. What's your name?
Yeah, he kind of mellowed out at the end there, didn't he? He just took his whooping there. This is from today. I'll tell you right now, it doesn't get worse. It doesn't get anything. She's a hot mess, but well behaved today. It's just everyone was behaving today. So this is what we've got.
Willis.
All right, Miss Willis, let me get your file. I'm Judge Middleton. And also with me is the distinguished Mr. Keith Stickley. He is the Chief Public Defender for St. Joseph County. Normally, we would do these in the afternoon, but a very busy afternoon and a very busy morning.
And former guest on Law Talk with Mike.
But Mr. Stickley was here with me, so we thought we would address this now. You got two cases. First file is 24390SM. That's a misdemeanor. In that case, it's alleged that on or about January 14th of 24, you did an assault upon Joan Gritzmacher, a resident of your household. That's charged as a domestic assault. You were arraigned on that charge, posted bond, and then you promptly didn't show up. Posted bond over the weekend, waiting on jail, failed to appear for arraignment. I did a show cause, and you failed to appear, and you got arrested last night, June 19th. How'd you get arrested last night?
I actually was picked up in Kalamazoo on Monday, and there was a hold for St. Joe.
Do you have a new Kalamazoo charge?
Yeah, I do.
What's that?
Possession.
Of which?
A narcotic under 25 grams.
So it'd be heroin or fentanyl?
Yeah.
All right. So you went off the grid on that one. That allegedly happened January 14th of 24. You already had a warrant out. On a charge of possession of cocaine. Let's take a look at that one. It might not actually be cocaine. In that case, the allegation is that on or about April 17th of 23, you possessed fentanyl as a second offender, making it a 8-year, as a habitual offender, making it a 16-year offense. You posted bond on that one and promptly never came back. You were in the Kalamazoo County Jail, and then we checked and you weren't in jail. You didn't show up and you got arrested last night. So I'm going to set the bond. First of all, on the felony case, I'm going to show a plea of not guilty. I'm going to appoint an attorney. I'm going to set a pre-exam conference for July 1st at 8:30. And if a preliminary examination is needed, it'll be July 8th at 1. The original bond was $7,500 PR and you failed to appear. I'm going to set bond at $7,500 cash or surety with the following conditions: no drugs and no alcohol, no weapons, no assaultive behavior, and that's it. Are you on probation or parole in Kalamazoo or just bond?
Just bond.
Do you have charges anywhere else?
No.
I do like how she tried to sell that she just was going about her life in Kalamazoo and got picked up because of an outstanding warrant. Then the judge asked, "Well, do you have charges in Kalamazoo?" "Oh yeah, I just got a new charge."
On this domestic violence charge, you got arrested actually on both of these at the same time and then promptly didn't appear on either one. On the DV case, I'm going to show.
I had a massive heart attack the day of my court hearing, and he passed away this past March, but that is why I missed my court. I'm typically not a flight risk.
All right.
Yeah, you are. I just feel bad for her. She's an addict or she needs the money or whatever. She's just deep into drugs but she's pleasant and she's polite.
We have a Dorset Street address in Portage. Is that correct?
Correct. That's my mom's address.
Who is Joan Gritzmacher?
It's my ex's mother.
All right. Appoint an attorney, set attorney pretrial for 7/1/25. Bond on that case was set at $2,000 PR. We'll now set it at $2,000 cash or surety. To say you're not a flight risk is not accurate. You didn't show up on the cocaine charge. Then you got arrested on both charges. You didn't show up, on the domestic violence charge. You got arrested in June on the fentanyl charge and the DV, and then you promptly failed to appear for both of those. You've been AWOL for 2 years. We're here all day, every day. All you had to do is contact us. And you get arrested on a new fentanyl charge. Are you going through withdrawal right now?
Yes, sir.
All right, I'm sorry, that's pretty rough. I'll talk to the jail services, but right now you're in a safe, clean place. I will see you on July 1st at 8:30 and we'll get an attorney to come see you. If you do post the bond, you need to contact your lawyer. Otherwise, your lawyer is going to come see you at the jail.
Okay.
All right, Ms. Willis, you're good to go.
No, this is your name.
Yeah,
I signed on this.
yeah, I told you that you can have me. I amended his motion.
No, I'm talking about his motions. Do we have?
All right, this guy is significantly more troublesome than that last defendant was, but This knucklehead wants to file his own motions despite the fact that he's represented.
Any of his motions with? I just have Tom's.
And he tries it with Stevens. Oh, no. No.
Oh, you want the defendant's motion?
Yeah. Yeah, if there's any, there's not.
He's fine. He's fine. He filed.
They don't go in, they don't.
I'm not.
All right. In 24 CR 2449, you were J.W. Marshall, present with your attorney, Mr. Burbank, and the state's attorney. Mr. Burbank is your attorney, correct? Yes, sir. He's filed a bunch of motions on your behalf. And, okay, these things that you're filing, the court doesn't accept that. You have a lawyer. This is what's called hybrid representation, which is disallowed under the law. You've got to either trust your lawyer, you run this by him, then he'll do what needs to be done. But this is not things I'm going to consider because he's the lawyer of record. You have a right to be heard, of course, but you can't have two lawyers unless you pay for them. You and him can't do it at the same time. He's been assigned. I don't know. Did you hire him?
No, I was.
Okay, you appointed. And okay, you want to represent yourself. Anytime you want to do that, let me know. And that would be a bad choice. It's always been a bad decision, but some people are insistent, and it never works out well for the defendant. But that's been our experience in this room with 18 and a half years and 600 jury trials. We can figure out what's the right way and what's the wrong way. We've seen it so many times.
What do I know after presiding over 600 jury trials? Just take it for what it's worth.
But this is, when you send this, the court's not going to receive it because you have a lawyer and he's the one responsible for filing the motions and representing you. So you don't want to get into a spot of where, well, if you're going to be doing it, he's gone. See ya. He's a wise man and he's a good lawyer. You got to trust. Run it by him. He knows how to do it and what is the best way to represent a defendant. Okay. Yes. All right.
Your Honor, if I may, one of the motions that he did file was for a possible bond reduction. I did file an amended motion that I signed on for. The basis, if I may address the court briefly, is that prior to the charge of murder being filed against him, he was out on bond. There are other cases in his file that he was taking care of, and he was on bond. He was compliant with all the rules and regulations, showing up to court, abiding by the rules and conditions. When this new offense came,
he was abiding by all the conditions of bond, except for that little bit where he went out and murdered somebody.
Then they, of course, put a new bond, raised the bond on the murder charge, and he's been in custody since then. He's asking for consideration, possibly reducing the bond down.
Okay, this in summary states the bond is presently at $1 million, and you are asking on behalf of the defendant that the bond be reduced to an amount that the court determines is reasonable. I know what the background is on why this was done this way, but does the state have anything to add here?
Yes, Your Honor. The state obviously would object to any kind of bond reduction. The defendant has 4 prior felony convictions, so he is a habitual offender. At least 2 of those are in sequence. Also, the nature of this crime, it's alleged that both the defendant and Jamal McCain, another the co-defendant, gunned down the victim in this case, and it is on video. You can see 2 individuals gunning an unarmed victim down, shooting him multiple times, both of the individuals doing that.
Anything you want to add, sir? You need to go? No, sir. Okay. All right. A couple of decisions the court's going to make. Number one, this court is going to deny the motion for bond reduction. I've reviewed your criminal history. I have reviewed the circumstances of the offense. Those are the key determiners in determining what a bond is under law. Number one, murder. Yeah, that is the most aggravated and violent crime unless it's multiple murder. Number two, you, according to this indictment, have at least 4 prior felony convictions that dating back 24 years. And not the least of which is a conviction of robbery in 2007, which is a violent crime. The others are, it looks like, illegal possessions of controlled substances, which are felonies. So this, if true, constitutes a habitual offender. Your punishment range is no less than 25, no more than life years in prison. And that's as serious as it gets. So this is, number one, a serious felony of murder, a most serious felony. It's the use of a firearm. Somebody is killed. It's a violent crime. You have multiple felony convictions, including another violent crime. And in reviewing the probable cause affidavit, this court finds that $1 million in bond is most reasonable under the circumstances of the case and your rich criminal history. So we're going to set this for trial.
We ask that it be said as soon as possible.
All right, y'all, what do y'all need to do to get ready? Because I'm going to try to accelerate this, please.
Your Honor, it won't take much. I think the co-defendant is currently set for October. So
anything can happen in a case.
I think we'd prefer to go on the co-defendant first in October. I think that's when we're set to go on that one. We've got everything ready. Mr. Marshall was arrested after this, after we received some additional information.
Lacey, I need to set right after the co-defendant's case.
Yes, sir.
Okay, we'll get it. Please note it. And
File real quick and then I'll
right.
get them a date.
anything else on this?
No, Your Honor, we'll be excused
Thank you.
for that.
That is all. Yes.
Maybe look at it again if we're not with.
Yes, sir.
Competency.
So he gunned somebody down on video with the co-defendant who's unarmed, and then goes and asks Judge Stevens for a bond reduction. That went about the way I thought it would.
Thank you. Appreciate you. Okay, what's your name?
Lakita Payne.
And this is case number 25058-234, People of the State of Michigan versus Lakeisha Sharmina Payton. Counsel.
For the record, Christina Harris on behalf of Lakeisha Sharmina Payton, who stands mute, waives a formal reading of the complaint, and Ms. Payton has been advised of and understands her statutory and constitutional rights.
Okay, the court's going to enter a not guilty plea on her behalf. Is there anything as to bond?
Yes, as to bond. Ms. Payton is a life resident of this area. She does live with the complaining witness, but it is her belief that he's left the address. She is employed on a full-time basis at a major retail establishment. She has attended some college. She's 48 years old and does not have any pending cases, is not on parole, and is
Judge Walmart wants their employee back.
not on probation. She also states that the complaining witness may have left and she has numerous cats in the house she needs to go attend to.
Ma'am, you didn't say the cat jumped on his wiener, did you?
This particular address is Section 8 housing, and she is on the contract. So we're asking for her to be able to return to that address, but not have any contact with the complaining witness, last name Ellis.
Okay. Well, the thing is, if he is living there, then she can't be there. 'Cause, ma'am, you're not to have any contact with the complainant, Daryl Ellis.
no physical or verbal contact, no contact by way of text or social media, no contact with his place of employment or residence, no contact through third parties. So I'm not sure whose place it is, but if both people are living there, if he's still there, you can't be there. No matter whose name, no matter whose name is on the contract, if he is living there, you can't be there.
Coochie. Gotcha.
Okay, no, wait. Okay, don't say anything. Okay, don't say anything.
Yes, ma'am.
So what the court will do is not put that you cannot go to that location, but understand that when you get there, if he's there, if he's living there, or if he's just there, you cannot be there. So it may mean that you cannot live there if he's living there. Is that understood?
Yes, ma'am.
We're asking for one-time police escort for her to get her belongings and her things so she can take those and go live elsewhere if she needs to.
Okay, that'll be granted.
Do you understand that, Ms. Payton?
Yes.
Okay, thank you.
Not to purchase or possess any firearms or any other weapons. This court's reading of the investigator's report indicates that there may have been significant alcohol consumption during this alleged incident. You're not to.
I would think so.
You're not to consume, purchase, possess, sell any alcohol or illegal controlled substances.
Might have just been the Holy Spirit.
Court is setting your bond in the amount of $10,000. This is going to be a personal bond. Have a probable cause date of June 26, 2025, 8:38. Oh, strike that. June 26. You have a preliminary exam hearing on July 3rd, 2025, 8:30 a.m., 36th District Court in front of Judge Jefferson. Okay. Did you hear everything, ma'am?
You say it's going to be June 23rd?
26. June 26th and July 3rd are your 2 dates.
Okay, yes, ma'am. It's kind of loud.
Oh. Okay, you can step away from the camera.
Yeah, I have to say she was surprisingly reasonable. That's what I was dealing with all day today. It was almost like a weekend because a lot of courts were closed. But I'm a professional. I powered through. With no material. Just old hearings that have already been done. And people behaving themselves on the few calls that did actually happen. That doesn't mean I still don't need my therapy with my chat. The show must go on, and so it did. Thank you for coming out. I will see you soon.